For the fourth time in 31 days, you are welcomed to the virtual launch of a publication of the Law Reform Commission. On this occasion, the virtual launch is of the Commission's report on capping damages in personal injuries actions. Fáilte once again. I think it is appropriate on this occasion to explain why there appears to have been such an enormous degree of productivity in relation to law reform at the Commission in these strange times. Under the Law Reform Commission Act 1975, the Commission consists of the President and 4 other members appointed by the government. When I joined the Commission as President in October 2018, my colleagues consisted of 3 part-time commissioners and 1 full-time commissioner. The 3 part-time commissioners, who were each serving a term of 5 years, which was due to expire on 31st August 2020, were Donegal O'Connell, Professor of Law, School of Law, NUI Galway; Thomas O'Malley, Barrister at Law, Senior Lecturer in Law, School of Law, NUI Galway; and the Honourable Miss Justice Carmel Stewart, Judge of the High Court. The term of each has now expired, and accordingly, pending the appointment by the government of replacement commissioners, only the full-time commissioner, Raymond Byrne, and I are currently serving as commissioners. At the start of this year, the members of the Commission were very conscious of the desirability of finalising before 31st August 2020 as many as possible of the projects which had been and were continuing to be under intensive consideration by them. Notwithstanding the difficulties between March and August this year, when meetings of the Commission had to be conducted virtually, the Commissioners had succeeded by 31st August 2020 in signing off on the 3 projects, the subject of the earlier launches, and on the report being launched today. I want to express sincere gratitude to my former colleagues for their tremendous work on those projects right up to 31st August last, which has led to an outcome which unquestionably is in the public interest. Throughout the summer period and into September, the researchers and the administrative personnel in the Commission have been equally busy in getting the reports and the discussion document ready for publication and published both online and in hard copy. Once again, I express sincere gratitude to each of those persons involved. The report being launched today stems from Project 9 in the 5th programme of law reform, which was approved by the government in March 2019. From the outset, the Commission considered it important that this project should have priority. The consultative issues paper was published in December 2019 and resulted in submissions from a considerable number of consultees whose valuable assistance is acknowledged in the report itself. Today, I reiterate the Commission's gratitude for that assistance. In relation to this report, the input of the principal legal researcher, Éire Dempsey, was extremely significant. And as the coordinating commissioner, I'm very conscious of that. I wish to express sincere thanks to Éire and to Rebecca Cohen, the Director of Research, and to Robert Noonan, Deputy Director of Research, for their work on the project. Of course, I'm not forgetting the importance of the input of Commissioner Byrne in all aspects of the production of this report. I express gratitude to him, not only for that input, but also for taking on the difficult task today of explaining the context and substance of the report in the presentation which is about to follow. Finally, for the last time, I say thanks to everyone involved in the projects at every level for the immense work which has enabled the launch of the 4 publications over the past 31 days. Buíochas. I now hand over to Commissioner Byrne Thank you.
Thank you, President. The report we're publishing today examines this question: whether it would be constitutionally permissible or otherwise desirable to provide for a statutory regime that would place a cap or tariff on some or all categories of general damages in personal injuries cases. Now, the Commission is very much aware of the wider context that forms the background to this report. And that wider context is the examination of the insurance market in Ireland, and in particular the cost of motor and public liability insurance. That wider context has been examined in the recent reports of the Cost of Insurance Working Group and of the Personal Injuries Commission. And those reports have already led to a number of significant policy initiatives and enacted legislation. The report the Commission is publishing today does not and could not address any of the broad policy questions that have been discussed in those reports. And therefore, those reports include discussion of issues like the causes of the fluctuation, the increases, decreases, and the increases again, in some instances, in the cost of insurance. The reasons for those remain highly contested subjects, and they are not discussed in this report. But bearing in mind that wider context, it's important, therefore, to emphasise that this report addresses a narrow and focused constitutional question, nothing more. The report also makes another significant point. This Commission is an advisory body only, and the constitutionality of proposed or enacted legislation is a matter primarily for the government in the first place, advised by the Attorney General, then for the Oireachtas, and ultimately constitutional questions are determined by the superior courts. Now, the Commission turns to the constitutional issues that have to be addressed in the question that's been posed by this project for the Commission. And the Commission has examined as best it can what those issues are and the constitutional rights that are engaged. Those constitutional rights include the right to bodily integrity, to be free from any law that would adversely affect somebody's health, and property rights, including in particular the right of access to the courts and to an effective legal remedy where a person's rights are affected. And also the right to equality before the law, which means that a person will not be subject to any arbitrary or irrational treatment under the law. Now, the report points out that legislation on capping general damages could be open to constitutional question if, in relation to any of the rights, for example, of bodily integrity or property rights, it didn't pass another test laid down by the courts, which is a test of proportionality. And that proportionality test has a number of elements to it. For example, that any limits on those rights must not be arbitrary. They must limit the rights as little as possible, and the limits must be proportionate to a legitimate legislative objective. Any legislation capping damages could also be at risk of a constitutional challenge if it inappropriately delegated the capping power to a minister without providing sufficient principles and policies to guide the exercise of that capping power. This is sometimes referred to as the principles and policy test or the non-delegation principle. Another important principle that arises in the context of this report is in relation to the separation of powers under the Constitution. The Constitution talks about three main institutions of state: that's the executive or the government, the legislature, the Oireachtas, and the judiciary, the courts. A question that arises is whether one of these three branches, the judiciary, must be the only decision-making authority in relation to the award of general damages, or whether the government and the Oireachtas can play a role. And all of these issues are issues that are considered in detail in the report. The other aspect that I've already mentioned is that this report examines whether it would be constitutionally permissible to enact legislation placing a cap on what are called general damages. And it's important in this respect to distinguish between that concept of general damages and another area of awards that's under the heading of special damages. Now, general damages comprise the sum of money awarded for a person's non-financial loss. That's the non-pecuniary loss it's referred to. These are also referred to as damages for pain and suffering, or for loss of amenity, and that compensates a person for the physical or mental injury suffered by the person. How much is awarded under that heading of general damages will depend on whether the injury is temporary or permanent, how it impacts on a person's overall life. For example, if somebody had played sport, would they be able to continue to play sport, or is it just a temporary problem? That's general damages. Now, special damages, by contrast, comprise the sum of money awarded for actual financial loss. This is pecuniary loss, such as loss of wages if somebody is out of work, or any medical expenses that may have been incurred in the past before a case is heard, or into the future if that is also involved in, for example, a very serious catastrophic injury. The future medical costs and future loss of wages may be considerable. Now, the Commission's report published today presupposes, on the basis of the law, that any legislation on capping damages would involve capping general damages only. This is because the courts have consistently decided, most recently by the Supreme Court earlier this year in the Ruth Morrissey case, that the award of special damages in a personal injuries case must always award full 100% compensation under that heading of pecuniary or financial loss, the special damages heading. Now, turning to the overall conclusions that have been set out by the Commission in this report. The report discusses all of the relevant law on general damages, and I'll come back to that in a couple of minutes, and also the constitutional requirements. The report discusses 4 possible models of capping legislation, and again, I will discuss those in a little bit of detail. And we've taken account of the constitutional requirements insofar as we can, and also the views expressed in the many submissions that we've received since the issues paper was published, as the Commission President has just mentioned, published last December. So we received a considerable number of submissions, and indeed, as a result of the volume, we extended the deadline for receiving those submissions. The main and general conclusion of the Commission in the report is that of the 4 models of legislation on capping general damages discussed, 2 of them appear to the Commission to be in principle constitutionally permissible. The report concludes that in respect of one of those, Model 4, which I will discuss, which are in relation particularly related to the guidelines that could be developed under the Judicial Council Act, that it would be entirely appropriate for that, the very recently expressed will of the Oireachtas, to be given some time to be applied in practice. And the report also concludes that in addition to taking the view that that model, Model 4, would be constitutionally permissible, that this is without prejudice to consideration of the merits of another model, Model 2, which involves a combination, as you'll see in a couple of minutes, of a New South Wales Act from 2002 and an England and Wales Act from 2018. So I'm just going to go through, as briefly as I can, the methodology that the Commission used in coming to those 2 main conclusions. And first of all, the Commission takes a detailed look at the development of the general law on the award of damages in Ireland. And the report notes that since the 1980s in particular, the courts have already developed a judicial limit, or what might be just called a maximum cap on general damages for the most catastrophic type of injury. And this now stands at a maximum of €500,000, and this was confirmed by the Supreme Court earlier this year in the Ruth Morrissey case itself. And in fact, that maximum amount of general damages was awarded in that case, in addition to the 100% amount of special damages in that case. The Commission also notes in the report that since 2015, over the last 5 years, the Court of Appeal in a series of cases has developed a 3-point scale to ensure that awards of damages are proportionate to the injuries suffered. And this case law also takes account of the upper limit of €500,000 for catastrophic cases. And the Court of Appeal has stated, and I'm going to quote just very briefly from one of those decisions, that the Court of Appeal has said that, quote, minor injuries attract appropriately modest damages, middling injuries, moderate damages, and more severe injuries, damages of a level which are clearly distinguishable in terms of quantum from those that fall into the other lesser categories, end of quote. Now, this 3-point scale and approach to proportionality means that the courts impose a definite amount or absolute cap in a specific case. They don't do that. They don't impose a definite amount, but provides a kind of bandwidth for the three different categories. And this mirrors the approach already applied in the Book of Quantum that we have had for a number of years, and in similar judicial guidelines that have been developed in, for example, England and Wales and Northern Ireland. Now, the report points out that this three-point approach of the Court of Appeal has had the effect that in a number of instances, the Court of Appeal has reduced awards where they think that the award has really been too high because the injuries are relatively modest, and sometimes those reductions have been up to 50% reductions. And in other cases, the Court of Appeal since 2015 has increased awards where the injuries have been at the more severe end of the scale. But the effect of that case law is that these have emphasized the need for proportionality in all cases. Now, complementing the judicial case law has been the legislation in this area, and that has included the publication under the Personal Injuries Assessment Board Act by the PIAB, by the Personal Injuries Assessment Board, of a Book of Quantum, the most recent version of which is 2016. And that has wide-ranging guidelines for the award of general damages, which are very similar to guidelines that are already being published, as I mentioned, in England and Wales and Northern Ireland, and are likely to be very similar to the guidelines to be prepared under the auspices of the Judicial Council under the recently enacted Judicial Council Act of 2019. And having looked at these developments in the case law and the constitutional issues, the Commission, as I've mentioned, refers to four models. These were four models of possible capping legislation for general damages that were outlined by the Commission in the issues paper that we published last December. And in that issues paper, we asked our consultees, and there were many of them who replied and responded to the issues paper, and we're very grateful for all the detail that they supplied to us. But we asked them to consider, was there any other models of capping general damages that they could consider and that might suggest to us. Now, none of the consultees did make any further suggestions, so the report published today is related to those four models in the issues paper, and we've returned to those, therefore, in the report being published today. And those models take account of, insofar as possible, the current law, as well as developments in other jurisdictions, including in particular Australia, as I've mentioned, in New South Wales, and also in legislation enacted in England and Wales. And the reason why they were selected is because those jurisdictions, Australia and England and Wales, have also developed case law comparable to the kind of case law that has been developed in Ireland, and then that has been supplemented, like in Ireland, with legislation enacted to address either some or all categories of personal injuries awards. So we have looked at each of these four models in detail in the report, and I'm just going to give you, again, a brief outline of what the Commission's approach to those four models were and the conclusions arrived at. So Model 1 then is a model that proposes a cap set by primary legislation, an act of the Oireachtas, and is based really on an analogy with how sentencing occurs in criminal cases. And in criminal cases, the courts impose sentences using a proportionality test, and that can sometimes range from imposing a suspended sentence up to the maximum range that might be set in legislation. So in some respects, you could say that analogy appears to be close to the kind of three-point scale that has been developed by the courts in relation to general damages, and comparable to the scales that are used in the judicial guidelines that have already been published in England and Wales and Northern Ireland. And while it can't be definitively predicted, it is likely that the same approach might be used in the guidelines that are going to be produced under the Judicial Council Act. Now, in the report, in terms of Model 1, the Commission concludes that it has the benefit in terms of constitutional tests of involving a piece of primary legislation. It would involve, if enacted, a piece of primary legislation rather than delegating that power. but it appears to be at some risk in the Commission's view because it would involve a mandatory type of setting of general damages. And while that might be able to withstand a constitutional challenge, the Commission considers that it would not be desirable to run that risk, and that if there was to be legislation even generally along the lines of Model 1, it would need to include some form of discretion to move away from a mandatory approach. So moving on then to Model 2. Model 2 involves a combination or a variation of two pieces of legislation, one from 2002 in New South Wales and a second from 2018 in England and Wales. They're both called Civil Liability Acts. Now, the variation that the Commission proposes by comparison with what's in the New South Wales Act is the possibility for a judicial discretion to disapply a cap or limit on damages. So the New South Wales Act, if it was just to be enacted, that would involve a mandatory or upper limit where the courts would be bound by those upper limits, would still have some ability to have a discretion within the bandwidth set out in the legislation, but it couldn't go beyond that particular bandwidth. So the courts would be limited to categorizing whether an injury was minor or modest or severe, but having done that exercise, it couldn't go beyond, the court could not go beyond the maximum cap set in the New South Wales legislation. So the Commission, in putting together Model 2, added the provisions for the so-called judicial uplift or discretion of the courts to go outside a limit that would be set in legislation. And that is allowed for, and that is part of the England and Wales Civil Liability Act 2018. There are differences between those two pieces of legislation. The New South Wales legislation is very general in its approach, whereas the English 2018 Act, in providing for a judicial uplift, it is just limited to a very particular type of injury, the so-called whiplash injuries. Now, in concluding on Model 2, the Commission considers that a direct transplantation of the New South Wales 2002 Act to Ireland would be unlikely to be regarded as constitutionally permissible in the Commission's view. And therefore, any comparable piece of legislation would need to include the judicial uplift that is included in the England and Wales 2018 Act. So that's the Commission's conclusions on Model 2. If you had those combined elements, then that would be, in the Commission's view, constitutionally permissible. On Model 3 then, Model 3 proposes that either Models 1 or 2 or a variation of them could be enacted, and if enacted, it would involve something similar to what was being proposed in the Private Members Bill, the Civil Liability General Damages Bill 2019, which passed second stage in the Senate in March last year. Now, the Commission has therefore modelled, if you like, Model 3 on that bill, and that bill bore some similarities to the England and Wales Civil Liability Act in that it proposed a delegated regulation making power rather than setting any specified amounts in the bill itself. But it had an advantage in the Commission's view that it set out some criteria or principles and policies on which the Minister for Justice and Equality would, under the bill's proposals, have determined the tariff for general damages in particular categories. On the other hand, the 2019 bill mirrored the New South Wales legislation in that it appeared to be mandatory in nature without any possibility of judicial uplift, and didn't contain any provision for, as the 2018 English Act provides, for some discussion with members of the judiciary. Now, the Commission concludes, therefore, in relation to Model 3, that in the form proposed in the 2019 Private Members Bill, that would be likely to be open to constitutional challenge on the basis of a number of factors, including the delegating issue and the mandatory nature of the cap. So on that basis, on the risks that would therefore arise in the Commission's view from enacting that model, the Commission takes the view that from a constitutional perspective, it would probably not meet a constitutional test and therefore would not either be desirable to enact such legislation. Then the final model that the Commission examines is Model 4, and this could be described as a model that's closest to, if you like, the current position, but it would envisage seeing the courts being involved in setting maximum upper limits for general damages and a proportionality test for other cases, taking account of the significant reforms that have just recently been enacted with the establishment of the Judicial Council and a committee of that Judicial Council, the Personal Injuries Guidelines Committee, under the Judicial Council Act 2019. And the guidelines to be prepared under the 2019 will be largely based on court awards, but there is a significant difference by contrast with the current Book of Quantum, in that the new guidelines being proposed under the 2019 Act will be able to depart from the current level of court awards, or if you like, the going rate. In addition, there's a section in the 2019 Act that will be commenced when the new guidelines are published, but has not yet been commenced, and which will provide that the courts will be required to have regard to the judicial guidelines published under the Judicial Council. But in addition, at the moment, the courts have to have regard to the Book of Quantum that's published, but in addition, when the new guidelines are published under the Judicial Council Act, the courts will be required to state any reasons for departing from the guidelines in a decision. Now, that currently does not apply in relation to any departure from the Book of Quantum. So that is certainly an additional obligation. Now, in conclusion, on Model 4, the Commission considers that caps imposed by guidelines under the Judicial Council Act would be likely to resist any constitutional challenge. And assuming that the guidelines are likely to broadly reflect the recent Court of Appeal case law on proportionality in damages, the Commission considers that the guidelines will meet a test of constitutional proportionality as well. And as I've noted, the courts will be able to depart from the guidelines, so it gives them a judicial discretion, subject to the obligation to state the reasons for which they do so. So those are the views of the Commission on each of those four models. Now, you'll be glad to know, if you're still with me, that I'm near the end of this overview, but I wanted to say something on behalf of the Commission in relation to the overall approach of the Commission on the project. We note that a number of consultees referred to and preferred each of the models. Some of the consultees preferred various models. A number of them certainly preferred Model 4, and that they regarded that as the most appropriate based on their analysis of the criteria. And a number of consultees said that even though Model 4 was their prepared option, Model 2 could, subject to the variations between the 2002 and 2018 Act that I've described, could be regarded as constitutionally permissible, but some of them said as a fallback option only. But as I've said, a number of consultees said Model 4, Model 3, Model 2, Model 1 was their preferred option, and have already said to you that in the Commission's view, we certainly have concluded that in principle, legislation, depending on how it's formulated, in terms of capping general damages, could be constitutionally permissible. How any particular proposal is formulated in practice is likely to influence whether it would be constitutionally permissible or not. For example, the Commission takes the view that imposing a presumptive cap rather than a mandatory cap, a presumptive cap, will, all other things being equal, be more likely to survive a constitutional challenge than a mandatory cap. And of course, it's the proportionality of the caps that would also be very, very important. Now, the Commission notes that, again, this is a limited and focused analysis of constitutional questions. And we're very conscious the context of the wider background, a very fast-moving number of developments. Even since the Commission was asked in 2018 to examine this particular limited area, there have been much developments in terms of policy and also in terms of legislation enacted since 2018. And we're very conscious then that our role is an advisory role, and that the government and the Oireachtas, as the Oireachtas is the sole lawmaking body and authority in the state, has its role. The government, in terms of its policy-making role, has its functions, and the judiciary have their functions clearly as well. Our role is advisory, and we absolutely are basing our recommendations on the best analysis that we think we have engaged in, but that it is a matter for others to determine whether to take any action on those views that we've expressed in the report. And as I say, this is one recommendation of over 33 recommendations made by the Cost of Insurance Working Group and the Personal Injuries Commission. 33 recommendations have been made altogether. This is one, this relates to one, and 71 actions flowing from those reports. So again, we're very conscious of the limited nature of the proposals that are being made here in this report, and that there are other matters that are being discussed in the programme for government that agreed in June of this year, and that also relate in some respects to that wider policy context. And it is no part of the Commission's function to review or examine what's contained in a programme for government, but we're just very conscious that that is the context within which this report is being published. And particularly then we're conscious that the report is being published against the background of the establishment of the Judicial Council under the Judicial Council Act in December of last year, that the Judicial Council first met in February this year, that the Personal Injuries Guidelines Committee was formally established in April, and that it will prepare draft guidelines later this year. So that all of this is part of the context in which the Commission is proposing its is publishing its report today and making its conclusions. So that's to emphasise the narrow focus of this project and report on the one hand, and the dynamic context and the wider context in which it has been completed. And the Commission concludes the report by stating that there is clearly merit in the perspectives of consultees who preferred Model 1, Model 2, Model 3, Model 4, and in addition, the Commission considers, and this is one of the conclusions of the Commission towards the end of the report, that it would be entirely appropriate and desirable from a constitutional perspective that the will of the Oireachtas recently expressed in the Judicial Council Act, and under which it has conferred extensive functions on the Personal Injuries Committee and the Judicial Council, that that will of the Oireachtas should be given some time to be applied in practice. And this is without prejudice to the consideration of any of the models that the Commission has discussed in the report, or any other model that may very well be considered. In any event, in conclusion, and I'm concluding now as well, that the Commission emphasises that in expressing the views in this report, the ultimate forums to consider what policy or legislative initiatives are to be taken on this or any other area are matters for the government, with the benefit of the advice of the Attorney-General and of the Oireachtas, and ultimately constitutional questions may have to rest with the superior courts. So that is in conclusion in terms of the analysis of the report, and I would refer you then to the details of the report itself.